So I hope I'm adequately audible to the participants. So this corporate law judgments discussing at the fag end of 2024 is always interesting. I've been doing this either writing articles or giving lectures on the you can say the yearly review of the judgments in corporate law, mostly company law. My focus today is most of the judgments or the orders of the NCLT, where there is some you can say some practical relevance in the day-to-day practice for the professionals, and how probably we can interpret the law, or how we can apply the law, or how we can adequately serve our clients in terms of consultancy, but with some you can say some reference to a particular judgment which is there in the present situation. So let's move to the presentation. So just before we go, I generally, after a lot of thought and lot of preparation and discussion with few professionals, I've just come out with why should we as professionals, whether company law professionals or income tax professionals or GST, why, or even any other professional, legal professional should read the judgments is basically it is important for a consulting. It helps in bringing some important perspective for the record keeping. Whatever decisions we or whatever consulting we provide to our clients, it is backed up with some court judgment or some analysis which is there, which we can refer at several point of time. Then there is awareness on the compliance of the company law and related laws, because we can accordingly sensitize the management and the professionals who are complying with the law. This has helped me a lot in the legal opinions. Sorry. And also in some litigation cases. Basically, it develops our application of principles of interpretation. So reading different orders helps us to bring a different perspective towards the law. And it creates a true value addition to the client or the, you can say the other party that we have with respect to the judgments. So let's move to few disclaimers, because firstly that this is a bit of an academic discussion, though I'll be referring to the practical implications of it. I'm just discussing prominent orders, not all orders. So there could be a order which may have some practical relevance, but considering the timeline, I've tried and found out around 8 to 10 orders that we can discuss. I don't have any interest in any of the parties with respect to the cases I discussed. And some orders may be appealed or they may be sub judice in the present situation, but I'll be giving some aspect of what is held in the present situation with respect based on the order which is passed. And most importantly, like not based only on my lecture, but you also need to go through few orders in detail to understand the facts of case. In my presentation, I'll be ensuring that I cover the facts, but there could be some minute aspects which probably we need to consider if at all you are applying it to your similar case which you have. So facts of case are absolutely important when we are applying the judgments in a corresponding matter or a particular case. So facts are important, and if you feel that there is a conclusion which is given by the court, and if you find that it is relevant, then you need to go back to the judgment and read the facts. So just few disclaimers and few important points before I start the presentation. Yeah, so there was a very recent Bombay High Court judgment in a particular case where they interpreted the provisions of the promoter, who is a promoter of a company, and basically freezing and defreezing of the shares of listed entities in a particular case where there was a non-compliance by a listed entity. So Yeah, just to give some background, though I have not put everything in the PPT, but just to give some background, there was one shareholder, Dr. Pradeep Mehta, and his father as well, who was the shareholder of a company. They were both the petitioners. So basically, they were holding shares in a company which was incorporated in 1989, and that in that company at that point of time they had physically subscribed to the shares of the company at that point of time at its incorporation, and they were neither directors nor active shareholders or active promoters in the company at any point of time from 1989 till 2004, 2005, or 2000, probably till the case was there. They were never active promoter, but considering that they were relatives of the promoter in a distinct way, they had subscribed to these shares just as a contribution, a family contribution that was made that point of time. Then the company flourished and they declared bonus, so the shares multiplied. They declared dividend, so they got the dividend over the shares. But if you see the uh, the the annual return and all the submissions that were made, these two petitioners were tagged as promoters, and based on which even the returns to the stock exchange were filed. This company was listed only on Bombay Stock Exchange, and so at a latter point of time, under the SEBI LODR, obviously they were required to comply with certain provisions of the LODR, specifically with respect to submission of financial statements. In one of the quarters, it happened that the company which is based in the India, that is the listed entity in which they were tagged as promoters, this company had a subsidiary in Hong Kong. And this Hong Kong-based company made a default in a particular, means there was a non-compliance at the end of the Hong Kong entity, which is a subsidiary entity, and because of which the accounts couldn't be finalized and the financial statements and financial results couldn't be submitted to the stock exchange within a prescribed time. So what happened was there was a non-compliance, apparent non-compliance, and based on which the stock exchange imposed a penalty. Obviously, there was a communication between the company and the stock exchange, but ultimately they imposed a penalty. The penalty was not paid within a prescribed time, and the next step was taken in accordance with the SEBI circular with respect to the freezing of the shares of the promoters. So obviously the company had active promoters, but considering that they were subscribers to the memorandum article at that point of time, these two gentlemen were also tagged as promoters, and this they came to know when one of the petitioners was going to invest in the Indian entity, one of the Indian startups. They were Singapore based, the petitioners are Singapore based, but they had, you can say, they wanted to invest in one of the startups. So when they wanted to hold the shares electronically, that time they got to know that the account has been freezed. And then they got a link that they had subscribed to the shares long back. This is a very small background to the entire case. So basically, what was discussed is who are the promoters of the company, what is the power of SEBI to freeze the shares of SEBI as well as other authorities to freeze the shares in the Demat account, and how these regulations have been drafted and prepared specifically in relation to the particular case. So what was observed or what was argued and what was observed by the Bombay High Court was that these were never active promoters in the company, and they were in fact promoters just for the sake of promoters at the time of incorporation, but they didn't have any active role to play in the company. And they also observed it was when the penalty was levied. That time, this observation was made by the Bombay High Court that if at all you all are interpreting the provisions of promoter as per the provisions of the company law, then it is necessary that the provisions of Companies Act, which provide the definition of promoters now, that ought to have been checked. So one of the checkpoint is under Section 92, which provides for filing of the annual return, and in that, there is a reference that if there is a promoter defined in the annual return, then he is a promoter. So this ought to have been checked by the you can say the regulatory authorities the latest return before they were going to impose the penalty. So they were not, you can say, the promoters, active promoters in the company. And if you see even the definition of promoters and that what they have gone, what they have provided in the Bombay High Court judgment is a very detailed analysis of who is a promoter, and they have given quite a few English judgments in relation to who can be a promoter and what will be his role in the company and what will not be his role in the company as well. So at the same time, this freezing and non-defreezing of the shares that was done, there was also no specific notice that was given to specifically the shareholders of the company. So therefore, even the principles of natural justice was not followed, was one of the observations of the Bombay High Court. As at the same time, it was freezing of the shares in the entire Demat account. So not just that company's shares were freezed, but also the other shares that were there in the Demat account, they were also freezed. So the petitioner was also holding the shares of ITC. Those were also freezed and they couldn't liquidate the shares. So therefore, this one of so there is also a reference to Article 300 of the Indian Constitution that with specifically in relation to the property, that shares are a property, and in relation to that there is also some reference given based on which the Bombay High Court has passed this judgment. So very important remarks that have been you can say passed by the or given by the High Court. One very interesting aspect was that the SEBI, the Bombay High Court interpreted SEBI listing regulations, SEBI Act, and also the SEBI circular, which was 2014 and 2015 SEBI circular that was there. So they said that the LODR regulation does not specifically provide for SEBI to freeze the Demat account, and they also compared it with the provisions of the SEBI Act. So there was no specific power as such, but the power was through a particular circular. So they compared the SEBI listing regulations, the SEBI Act, and then the SEBI circular. They said that this circular overrides the provisions of the regulation and the Act, and therefore you can say at the same time they are not promoters as well. So therefore it was observed that this is definitely not in the interest of the you can say the petitioners. So I've just tried to put some important summary or an important remark with respect to the. I'll be sharing the PPT, so you all can go through the same. So there is also a reference where substantive law and procedural law and circulars has also been discussed in this particular judgment. So very interesting. I'll also be giving a cross reference of where we can apply. So for example, if we come to the provisions of the present regulation, the present amendment that the SEBI has, that the MC Ministry of Corporate Affairs has introduced. So there was a notification on 27th of October 2023, which we are well aware of, where the MCA mandated demat of shares of not small companies, that is private companies. In that, there is a definition or a reference of a promoter. So I'm just trying to interlink, and there are many provisions in company law where there is reference of promoter, but the latest one being this one. So there is a reference which says that a private company, like they should hold the shares in Demat, and they cannot come out with different means issue of securities, buyback of securities, issue of bonus, rights offer after the day when it is required to comply, and the entire holding of the securities of promoters, directors, key managerial personnel has been dematerialized in the provisions of the Demat. So there is a reference of promoters here. So it may happen that probably we at some point of time private companies have to interpret the provisions of promoter, and they may not have adequate material maybe for this purpose. So probably this judgment may be of some relevance to check whether, or at the same time, in one of my very recent matters, the issue was about a private company where they wanted to the private company wanted to reclassify one of its promoters as non-promoters. So based on whatever company law regulations we have, there is no specific provision, but they wanted some advice on this. So these are very critical issues, and this was not in relation to the Demat, but there are quite a few occasions where they need to reclassify the same because they were subscribers in 1990, and they are no more the active promoters in the company, but they have been tagged as promoters. So that this is one of the occasions where such situations may arise for even a private company, obviously for listed company as well. So this particular circular is relevant for private, public, unlisted, listed companies as well. So not circular, this particular judgment. So quite important judgment and observations. So this was one part of it. If you have any queries, you can put in the chat box. We'll be having one Q&A session. So I may cover your query as well. So we come to the next point. Yeah, the next case actually. So basically, it was of the NCLT Bangalore bench, where the matter before the NCLT Bangalore bench was for conversion of a company limited by shares, which is a normal private company, into a company limited by guarantee. So there was means the petition. So we will come to the brief fact. So the petition was filed under Section 230 under the compromise arrangement, read with the rules, and with Section 18 and Section 66. Because considering the fact that the company limited by shares will be converted into a company limited by guarantee, so there won't be any share capital. So there would be a capital reduction. Therefore, they have given the reference of Section 66. So this was made by one of the entities based in Bangalore, and the objective of this entity, or the objective was that probably they don't need capital now, and they wanted to convert that into a company limited by guarantee. Generally, that was the general purpose for such conversion. So if we go through the company incorporation rules of 2014, then there is only a reference of the conversion of a company by a company limited by guarantee into a company limited by shares, but not vice versa. But this company had a particular issue. So considering that there is no provision in the company law, the matter was routed through Section 230 of the Companies Act, that is the compromise arrangement. Now, this is probably based on the definition or the interpretation of the word compromise and arrangement, which was there under the Companies Act 1956, which was quite wide and extensive and covered different ways of corporate restructuring in the company, if at all there is no specific provision given in a particular law. This was a brief summary of what was held in the earlier law. So therefore, probably they would have, you can say, routed this particular petition or filed the petition under this particular provision. So this was this was the conclusion. There were quite a few, you can say, observations or the representations made by both the parties, ROC, RD, and the petitioner entity. So this was the conclusion of the NCLT. NCLT observed that there is presently no rule for allowing the conversion in the reverse direction from the company limited by shares to company limited by guarantee. And merely because the rules have not been notified, it doesn't mean that they cannot convert. So this was one of the observation. And they said that this was covered in arrangement between the company and the members. And they referred to the provisions, the basic provisions defining the company limited by guarantee. It was also argued that if a private company can be incorporated without an adequate share capital or a minimum share capital, which was introduced by way of an amendment, then there can be a company which can have no share capital at a later point of time as well. So it is not that only at the time of incorporation you should not have capital, but it may happen that after 10-15 years, you can be a company without share capital. That was also one argument made before the Honorable NCLT bench of Bangalore. So this was one of the matters. Now, just to draw the analogy or just a comparative analysis, presently in the present structure of the company law, since we don't have a situation where a conversion is possible in under the Companies Act by a particular rule. So just a possibility that can the present Section 8 companies, which are limited by shares, a company limited by shares, can be converted into company limited by guarantee. Answer is yes, based on this particular judgment. Uh, Till now, the MCA has not amended any of the rules. So probably based on the judgment, you can say a Section 8 company can convert into a guarantee company, but they have to be filed. They have to go through the process of filing it under Section 230, which may be time consuming as well as not that cost effective for a Section 8 company. But yes, this option is definitely there for the company under the present structure. Then we have, I know I'll be taking a case after case very immediately. Generally, that doesn't happen in a one-to-one session, or in a physical session. But in a webinar, I will be discussing, you can say, quite a few cases back to back. But if there is any query, you can just drop in. So this is another case with respect to the buyback and capital reduction. So there are quite a few judgments which talks about selective capital reduction. And if we see the provisions of Section 100 of the Companies Act 1956, and there are quite a few judgments of the High Court under the previous law, which discussed about the capital reduction provisions. Uh, there were quite a few innovative ways in which capital reduction was allowed for certain companies in certain cases, obviously genuine cases, but the this has become now quite interesting considering the fact that the law has changed and there is a specific another provision that has been introduced in the law which talks about the capital reduction. So we'll just be going through the provisions. So there is a company, Philip India Limited. Presently, it is an unlisted public company, now delisted. It was, I think, so listed till 2004. So the parent shareholding is around 96-97%, some odd number. And the public shareholding is just 3.87 or that much number of shares. Very minuscule number of percentage. But if you see number of shares, there are quite a few number of shareholders. So basically, the parent company and the company wanted that for administrative purpose and for all ease of, you can say, shareholders communication and ensuring that there is easy administration of the shareholders. The company had proposed that they will be buying out the minority stake through this particular petition, which was filed under the provisions of capital reduction. So the objective was to pay the public shareholders based on a fair value as a consideration and provide an exit. So very interestingly, but not very encouraging observations by the NCLT Kolkata in this matter. So they wanted to provide exit and they wanted to save on the cost. This was the reasons or the objective of the scheme that was filed before the NCLT. So what was actually observed by the NCLT was that, I'll just check if I have mentioned. Yeah. So there is a particular provision in the company law now under the Companies Act 2013, which specifically states that under the present provisions of the company law, there is under Section 68, there is there is a subsection which says that nothing in this section, that is Section 66, shall apply to buyback of securities of its own securities by the company under Section 68. So if a company is going through the process of capital reduction, then the provisions of buyback shall not be applicable. So what, based on the petitions, pleadings, and arguments before the NCLT, it was observed that the petition, though it was filed under Section 66 of the Companies Act, it was under, it was as good as buyback of shares, but under the garb of Section 66. That is broadly what the NCLT observed in this particular case. Basically, they were, the company is buying back the equity shares from the minority shareholders, but under the provisions of capital reduction, probably because of the, you can say, the amount or the way in which it is going to buy back. So that was the case. So they discussed each and every clause which is given in Section 66, which talks about extinguishing or reducing the liability. Then it talks about cancelling any paid up capital. Then it is paying off any paid up share capital which is in excess of the want of the company. So all this was analyzed, and it was observed that this petition is mostly, or is under Section 66, but with an intention of Section 68, which talks about the buyback. So it says that there is nothing, not even in the written note involving the. So this is what has been observed. So just mentioned on the screen. It was observed that Section 100 of the Companies Act 1956, the provisions were wide enough and there was no specific bar on the buyback from minority shareholders. And therefore, quite a few schemes were sanctioned and approved. So this capital reduction provides for a specific bar, and there is a specific provision now, which is subsection 6 to Section 66. And what was the conclusion was that in the current facts and the, you can say, the circumstances, the capital reduction is only incidental to the main object of buyback, even as per their own pleading. So probably based on that, obviously they would have gone through all the notice. Yeah. Now there is another judgment. Yeah, sorry. Now there is another judgment with under section 233, which talks about the powers of the regional director in a particular case. So this was, you can say, an amalgamation or the merger of a wholly owned subsidiary. There were around 4 to 5 wholly owned subsidiaries which were going to be merged with the holding company. And this application was made under section 233, which is the provision for fast track merger. Now, there is one more judgment, but not in this year or the earlier year, with respect to the judgment with respect to the powers of the regional director. And this is quite an interesting judgment because it is not only one particular provision or a particular subsection has been interpreted, but based on the earlier provisions or the earlier subsection, one particular provision has been interpreted with respect to the powers of the regional director. So it talks about solvency of the companies. It talks about the approval of the shareholders. It provides for how the application is to be made to the regional director. So all these provisions are given in section 233, subsection 1, 2, 3, 4. And then it says that what regional director can do if at all it finds that the scheme is not in public interest or they have not complied with any of the conditions. So in this particular case, what happened was when the matter was before the regional director scrutinized the balance sheet and observed that the companies were not solvent. Okay, that was one of the that is in fact one of the conditions for the merger under Section 233. But as per his calculation, the companies were not solvent. And because of that, he rejected the application. And if we see the provisions of Section 233, subsection 5, it says that if the RD, after receiving the objections or suggestions, or for any reason is of the opinion that the scheme is not in the interest of public or the creditors, it may file an application to the tribunal. So basically, it was observed that his application to the tribunal is an optional application, or it is at his discretion about filing the application to the tribunal within a period of 60 days from the receipt of the scheme. So he has around 60 days to review the scheme. That is basically the issue. So does he have a discretion, or is it mandatory for him to file? That was actually interpreted. So in this particular case, the application was rejected and the parties had to file a writ petition before the Bombay High Court about on this particular matter. So the petition was filed before the so the brief facts. So probably I can skip this because I have discussed this in brief in the earlier part. Yeah. So this is what it was observed, that whether we need to read subsection 2, 3, 4, and 5, and the phrase may use in subsection 5, how should that be interpreted? Whether it is discretionary or whether it is mandatory. So this was observed. So the conclusion was that this phrase, which is may used in subsection 5, that they can file an application before the tribunal, shall be interpreted as mandatory, because that is how otherwise there will be always a discretion with the government, and this may shall be interpreted as shall is one of the very important observations of the Bombay High Court, that when the company is involved in the scheme, it would be at the mercy of the central government if the scheme is rejected without any adjudication. It is therefore mandatory for the central government to make an application to the tribunal and get the adjudication of the issue. So probably it would be heard more in detail, and there would be, you can say, detailed submissions before the NCLT as well with respect to the. So basically, the powers are not completely discretionary on the fast track merger with respect to the regional director. So quite interesting, because Section 233 has been interpreted in that manner. Probably just my observation or my analysis is that when we have the next round of amendment, this subsection 5 may be amended, wherein the word may will be substituted by shall, and then there will be a statutory provision, and then we need not probably rely only on the judgment of the Bombay High Court. This is just my observation based on this particular, but very important judgment, because it takes away the discretionary power of the statutory authority and it asks for an adjudication before the tribunal. Yeah. This is another case where the ratification by shareholders was interpreted in a particular case. This case has a lot of background, and so there was a company, and there is a corresponding case as well in the case of Telescope Ventures. This Telescope Ventures case is one of the orders of the Securities Appellate Tribunal, which was passed in the year 2022. And I had authored a very detailed article on Taxmann for this particular case. Now coming to the present case, in the present case, this is that of Alps Motor Finance Limited. So this is a listed entity. In the listed entity at that point of time, during a particular period of June to August, so June, July, August, in the period of just 3 months, the company made 6 preferential allotments, and they made all the requisite approvals and disclosures to the stock exchange and all. But what happened was that it was observed that the amounts that they received through the preferential allotment were not used for the specific object for which they have been raised. They were used for something else. But The investigation by the stock exchange started in 2016. Okay. So this was a matter which got over in 2013 and the investigation started in 2016. And then SEBI also asked for certain information and SEBI also carried the investigation and issued the show cause notice. So this is still 2016. Then based on that, the SEBI concluded that yes, there is a need for, you can say, opportunity of hearing. So they asked for all the evidence and the hearing was conducted. But ultimately, there was a non-compliance and accordingly, the penalty was imposed under the provisions of the regulations and the PFUTP regulation. So allotment made in 2013, violation was observed in 2016 and show cause notice was issued in 2023. So rather than just the the ratification, this case is more important from the perspective of from the perspective of when the investigation ought to have been started and all. So there are two issues in this. One is on the ratification and second is on the way in which the investigation was carried out. Delayed investigation was carried out in this particular matter by SEBI and stock exchange. So considering that it was an inordinate delay, SAT observed that yes, this is a, you can say there is no justification in issuing the show cause notice because even as a normal business concern, it would happen that the funds would have been utilized for the purpose of it at some point of time. So ratification was one aspect, but this was another aspect in the particular case. But on the ratification front, it was observed that if the company has ratified before the issuance of show cause notice, then the ratification is valid. So just take an example. In this particular case or in some other case, the event has taken place in 2013 and this was just observed in 2016 by the Bombay Stock Exchange. And now there was just a communication between the two authorities, between the authority and the company. However, once they got to know that there is a non-compliance, they took the shareholders' approval, saying that under the provisions of the company law and SEBI regulations, the action of the company is ratified. And after that, they received the show cause notice. This exactly happened in this particular case. And considering that they took the shareholders' approval, the matter was in the favor of the company. And then there was an appeal to the Supreme Court saying that since they have misused the company's funds, then still in this case, there was, you can say, uh, considering that they misused, this ought to have been penalized or the company ought to have been penalized. But that was not the observation even of the Supreme Court. So this ratification is valid. And they have given reference to the telescope case in the SAT judgment. And there are quite a few judgments, not only of the company law, but on the concept of ratification. And there are quite a few provisions also in the company law, which talks about ratification of the resolution or ratification of a particular action taken by the board of directors or any authority in place. So very important judgment from the perspective of some other provisions of the company law, which talks about ratification. Just to give an example, probably under section 185, which does not explicitly talks about prior approval. If we go to section 188 of the Companies Act, there is a specific provision which talks about prior approval of the shareholders. That is the case even in regulation 23 of the SEBI listing regulation. But there are a few provisions in the company law which talks only about approval and not a prior approval. Obviously, the language of the provision is equally important. So we need to consider that as well. But where the law talks only about an approval or a consent, then the question would be, can you take the ratification at a later point of time? Is also an important question in certain cases. So this judgment of SAT and probably the order of the Supreme Court may be of some help at that point of time. Yeah, this is what they have interpreted on the ratification. In the SAT order, they have given a reference to the similar order which they held it in the Telescope Ventures case. So in a way, the company was saved because they obtained the shareholders approval before the show cause notice was issued. That is probably one observation. So this is just the order of the Supreme Court that there is nothing to interfere in the particular judgment. Yeah. So we come to the next judgment or the next order, where basically the question was whether notes to accounts forms the part of the balance sheet for companies. Now, obviously, this answer prima facie for most of the professionals would be yes, there is no doubt about it. But what happens generally is that when we do the annual filing and when we have to attach all the financial statements, then considering probably the size of the e-form and all the technicalities, it may happen that probably notes to accounts may not be attached, and based on the probably the inspection scrutiny by the ROC, it may happen that the company receives this particular communication saying that this is not adequate compliance. So based on the judgment or the observations of a Supreme Court in the particular case of the state of Bihar versus one healthcare company, what happened actually, this is not a pure company law matter, but the issue was that there was a particular society and they released a tender for operationalizing and management of fleet of ambulance and mortuary vans for integrated centralized call center in the state of Bihar. So they asked for certain vendors to submit their, you can say, their services or their bid for the services to the particular society. And then the society took into consideration all the bidding process. And in one of the cases, one of the companies, it didn't submit it submitted all the financial statement, but it didn't submit the notes to accounts. And the question before the authority or even the society and then the High Court when it where it was appealed, it was observed that if that is not submitted, then these are not adequate submissions before the for the bidding application, and it is not a complete bid application, and hence it is liable to be rejected. That was broadly the observation of the society, and then the matter was obviously appealed, and it was before the Supreme Court. That is how the case has been, you can say, before the Supreme Court, and it was observed that yes, this is notes to accounts are essential part of the financial statements and explanatory notes of accounts are an integral part of the balance sheet. And this is the observation. They have referred to the provisions of section 134(7) of the Companies Act referring to the notes to accounts, and balance sheets can only be understood by going into the factual narration made in the explanatory notes to the accounts. So explanatory statements and balance sheet goes hand in hand. So this was just one observation. This is just from the perspective of the compliance that we need to ensure. Probably not that you can say not that very important, but yes, it is. It is just a reminder that notes are an integral part of the financial statement. Now, this related party transactions is quite interesting, debatable, and always open question for all when it comes to the SEBI listing regulations read with the Companies Act, specifically in relation to the compliance. And the most important part for the SEBI listing for the SEBI or the listed entities is materiality threshold. This is one very important aspect in the entire process of the related party transactions, right? So this was what was interpreted by the SEBI, which was appealed before SAT, and I think the matter is before now the Supreme Court. But we are just referring to one of the issues before SEBI, and then some references to the SAT, Securities Appellate Tribunal. So this is the particular regulation based on which the issue was there. before the SEBI in the case of Linde India Limited Company, a listed entity. So this is under SEBI listing regulation that basically the issue was there were two issues. First issue was on the materiality, that how the materiality is to be interpreted in cases. That was one. And second was with respect to the related party transactions, how it is to be considered in certain companies when it comes before the, you can say, when it comes before the shareholders approval. So these were the two aspects before the SEBI in this particular case of Linde India. So when it says materiality of 10% of the company's annual turnover in the previous financial year, it talks in relation to a particular contract with the company, and it includes the transactions which is made by that entity during that year and the other transactions made by the company during. So it is to be considered collectively for all the transactions which have been made by the company throughout the year, not just one transaction, but under a contract, probably the multiple transactions that would be covered. Now, this was, you can say, one of the issues before the. So to interpret the provisions of the SEBI listing regulation, and specifically in relation to proviso, they applied the literal rule and they interpreted the provisions of in a contract, which is there in the SEBI listing regulations proviso, which says that you have to consider, or you can say, a contract, not just one particular contract, but you can say multiple contracts for multiple transactions, but to be considered in that particular year collectively. That was one of the observations, and a very important or a critical observation in relation to the SEBI listing regulations, which enhanced or probably confirmed the interpretations of the SEBI listing regulations in relation to section regulation 23. So there is this 10% was to be calculated. Probably this is just an extract of the SEBI order. SEBI order is a combination of the comments of SEBI as well as facts of the case. So, but very important observations made with respect to the materiality to ensure that they take the shareholders' approval at an appropriate point of time. Because this materiality then triggers the prior approval. There is no question of ratification over here, but it triggers the prior approval. So companies are required to accordingly calculate or consider materiality and then go to the shareholders' approval. So this is a very important case before the authorities. Generally, we have the cases before the companies, but not a particular matter before any authority. And there are very limited cases before the SEBI in relation to the related party transaction. So therefore, this is one of it, which talks about the materiality and the shareholders' approval. So what the company was saying, that you have to consider materiality for separate contracts and separate transactions. I mean, whenever there is a transaction and if there is a separate contract, it is necessary that the materiality is to be counted separately. But the observation was SEBI was that if this is to be considered, then it would be possible for every company to structure all the transactions as RPTs, and such a move would not need to be placed before the shareholders for approval. All that will be required will be the company to ensure that all such transactions are pursuant to the different contracts. So there is a provision which says that it includes a transaction and all the transactions made during the year, and that is to be counted for the purpose of materiality. And there was one more issue between the company, that is Linde India, and Praxair India Private Limited. That so basically what happened was that the entity which is the parent entity, the Linde India, that wanted to allocate certain business to its subsidiaries, and it was not on record anywhere specifically, but it was through, you can say, the business was then, you can say, taken up by the subsidiary entity. So there was an allocation of business that took place. So the issue before the SEBI was whether that allocation of business also amounts to related party transaction. That was one issue which was answered positively. But then obviously for the valuation and all, they approached to the stock exchanges, and then they were required to appoint the registered valuer. So obviously, if this business amount also goes and exceeds the threshold, then shareholders approval was required. But if it didn't, then probably there could have been some other non-compliance. So this was also the issue before SEBI and also SAT, because this, I have to be very honest, this matter is sub judice, but still broadly these are the facts before the participants on the aspects of the related party transaction. Yeah. This is another case which talks about the liabilities of the professional who was involved, who had signed a particular report and submitted to the statutory authority. He was an authorized signatory, and he was signing it as the duty of a company secretary, but not, you can say, when the prosecution was initiated, it was initiated only against him and not against the directors of the company or the company itself. So we'll just come to the case so that the participants can understand. So there was a scheme of amalgamation between the company and its wholly owned subsidiary, and the shareholders creditors were meetings were convened, and the approval was taken, and the company secretary of the company was, you can say, the authorized representative in that particular case. So there obviously we have to submit declaration that the scheme was approved with requisite majority. So the issue also over here was uh, the 90% or 9/10 of the approval that is required, whether it is present and voting or whether it is out of the total number of shareholders. So obviously the you can say the law provides for it, but considering that, the requisite majority was also one issue over here. So when the application was made, the ROC observed that it is not, you can say, a complete or adequate submission to the statutory authority, and therefore they filed a complaint under section 447 saying that this is not adequate and requisite majority was not obtained, and still the application was made before the regional director with respect to the merger of the company. So accordingly, the show cause notice was issued, and this show cause notice was appealed before the High Court, that is the Kolkata High Court, and the observations, and it was prayed that the petitioner preferred that the instant revision praying for the squashing of the complaint and proceedings pending before the special court. So now these are the observations of the High Court. It says that the petition of the petitioner, the petition of the complaint, that neither the company nor the persons who are in day-to-day charge of the company were made party. So even if the particular authorized signatory has signed it, it was observed that the company as well as the person in charge of the company ought to have been parties to this particular complaint, and therefore it is not only he who would be liable, but even the other parties as well. Therefore, since only he was issued, the particular, you can say, the petition was squashed. Yeah, these are some observations of the High Court. Yeah, so even though we have come to the Q&A, in my presentation, I have not included one judgment, though it is an important judgment of the Supreme Court, which is in the case of Association of for Democratic Reforms versus Union of India, basically the case on the electoral bond. And but still, I feel that this has a limited application, and this case is which I am referring to it now is quite important from the perspective of constitutional law and the election process. There is also reference to the income tax law, RBI Act. So, though I have not referred to that case, but the observations made under by the Supreme Court in this particular case are equally important. Uh, so, yeah, so that was also one case which I wanted to cover, but I was aware that considering that there are so many cases that I'll be covering with a lot of practical relevance, I thought of not covering that in detail now because that could have not, you can say that that could have taken probably more 15-20 minutes, considering that quite a few provisions of Section 182 are not constitutional and they had provided on how the you can say the provision has to be applied in the future as well, which is provided in the judgment. But I'm not able to take that. But and also it has got a limited application for corporate law professionals, as I understand. So probably I couldn't take it. But these are basically few 8 to 10 judgments that I've covered